deployment of the seminar there's an element of formality about it, but what we know is you people know as much as we do, or else you wouldn't be here. And it's a very living environment, and that's what tonight's seminar is about an update. In the mix and mingle time afterwards, don't hesitate to give us some feedback too, because we're often asked by the minister or whoever, what do we think, what should happen? And one of the topics tonight is, I guess Hannah is going to speak to about what's on the horizon, and all of us wish we knew, particularly we knew what the court was going to do. I suppose that's our business, isn't it, that cases have that. You've seen the agenda all go up on the screen, but I just wanted to make a couple of observations about what we're not dealing with, simply for completeness. Pay equity in May this year, controversial. The number of people affected was largely the public sector, and you can still take a claim, but it was about 33 claims were dismissed. So for completeness, I need to mention that. Similarly, partial strikes, that's industrial law stuff, very specialised. That came into effect in July this year. If there is a partial strike, you can deduct, but that's really specialist advice, but I mentioned for completeness. Employee remuneration disclosure in August this year. I don't know how much of an issue that actually was. Happy, as I've said, to receive your feedback and afterwards. Whether it is an issue, but anyway, just for completeness, the law has changed there. Wage theft by employers, that was earlier this year, I think March. That's quite serious if you did do that, but with any criminal matter, you've got to have intention, so it can't be a mistake. But there was always the penalty provisions if you didn't pay someone correctly, where the line is between mistake and deliberateness. There'll be a court case, hopefully no one in this particular room. So just wanted to say that for completeness. On the 5 topics we will deal with, as some of you in this room know very well, and I won't identify Andrew as on collective bargaining. He knows a thing or two and is very well involved in a number of industries. Scott's going to talk about redundancy and the increased obligations the court imposed about the obligation for redeployment, etc. Simon is going to talk about health, mental health, medical incapacity, difficult areas, always changing, and I think more claims than previously. Jaya and Anthony are going to give us an update on case law and tell us what Uber means, who's an independent contractor, and who's an employee. That's an important one. And then, as I mentioned at the start, Hannah is going to tell us what's on the horizon. So it will then finish with a mix and mingle, and we're keen to hear from you what's happening in your horizon. The speakers will just come up one after the other. Thanks very much and enjoy it. We promise to run to time. Yes.
It's a very courageous promise to make it busy in the process. All right, I'm going to try and be brief and briefly talk about collective bargaining. I'm going to talk about 3 things really. The first is my experiences of this year. The second, contrary to what we just said, I am going to talk about partial strike pay deductions. And then third, I'm going to talk about what's on the horizon next year and what's likely to change in collective bargaining land. So if I can start with my experiences for next year, as somebody down there in touch. First of all, I think one of the first key features of the landscape at the moment is that it seems to be reasonably easy to do 2- and 3-year collective agreements at the moment. in the middle of COVID and all the turmoil and the recession and the boom and the bust and so on. It's really hard to do long-term deals, and a lot of the deals in that period were only for a year. It was a nightmare for everybody because we'd only just finished bargaining them and it was time to start all over again. I'm finding the unions pretty receptive to doing at least 2-year deals, and sometimes a bit longer, sometimes 3. The hard thing about that is that 3 years takes you out past the next election cycle. The unions are optimistic that the world's going to change in October, November next year. The second key feature is that most of the deals, most of the time, the year 1 pay increase has been 2.something%. At the beginning of the year, CPI was sitting at 2.3%, and people were confident it was going downhill. Trump then started throwing tariffs around like there was no tomorrow, and got a bit nervous, and the inflation rate started to creep up again. And so more recently, 2.7, 2.8 has been sort of the figure. But far and away, the deal for year 1 is 2.something. It's settled. There are, of course, some exceptions. My favourite group of bus drivers had just ratified a 0% pay increase. Pretty smug about it. But there are very special reasons for that. Then for the out years, past year 1, almost all the deals have some version of a CPI formula, CPI plus a bit, or 2.5%, or CPI, whichever is greater, but something that links to CPI is still far away most common for the out years. And then perhaps the other 2 key features of the year is that the unions continue to be desperately short of resource. They really struggle to retain staff, and you see that in so many ways. Trying to get the unions to actually come to a bargaining meeting and schedule a date and turn up and prepare for a bargaining session and stuff is really hard. Bargaining with the nurses, they are so busy with their public sector nurses strike that they haven't got time for a private sector hospital. One way or another, we're experiencing that a lot. And also experiencing ongoing high staff turnover on the union side of the table. Start with once or twice, which is frustrating. And then the other really interesting thing is that the unions just are not as powerful as they used to be. If you did a deal at the table, the deal used to stick. It used to get voted up because the union was in charge. They simply don't control the comms anywhere near as much as they used to. And the staff talking to each other on various WhatsApp and other social media programs means that what the union says at the table may or may not be what the staff are thinking and what the staff are saying to each other. And the prospect of going to a ratification meeting, even if the union are trying to get it ratified and still not voted something that's plagued my experience of bargaining this year. So it's a quick take on what 2025 has looked like. There is one significant statutory reform that is worth discussing, and that is the introduction of pay deductions for partial strikes. Essentially, the legislation allows you to deduct either 10% or a proportionate deduction for the extent of the strike. Somebody is required to make 100 widgets a day. If they only make 80 widgets a day, deduct 20%. Unfortunately, the real is never that simple. Trying to work out how much, what the real value of the reduction of the partial strike actually is pretty hard. And so far, most people seem to be 10% formula. Almost as soon as the legislation was passed, it was in court and being tested. The first case involved NZEI and the Ministry of Education. NZEI has members who are various education support people who manage special education cases. They went on a partial strike by way of an overtime ban and by way of a refusal to take on new cases. Ministry of Education said great, we'll deduct pay by 10%, and the saving to the ministry for the period of the strike is going to be something like $500 million. the union went rushing off to court to say that's unfair because most of our members weren't actually on strike because they wouldn't have worked overtime. And if they wouldn't have worked overtime, then the fact that we said they weren't going to work overtime actually didn't matter at all. And therefore, they weren't on strike. And therefore, you couldn't make a partial pay deduction. It was all dealt with very urgently there on an interim injunction basis. And the court said, well, look, you did give notice that they were going on strike, and they did go on strike, and some of them may have overtime. And so that's probably enough for the strike. And Ministry of Education was about to make the reduction. About 2 weeks later, a different version of the argument arose with NZNO, went on a partial strike. They announced that the nurses would refuse to work outside a surgical ward if you're a surgical nurse, or ICU if you're an ICU nurse. And often nurses who are basically working in one area nevertheless cover the nurses in the other area. Again, the Health New Zealand proposed to make a 10% pay deduction, and basically the same arguments were run. You can't tell who's actually on strike because unless the nurse was instructed to work somewhere else, then they weren't actually on strike. The limitation that we announced that no practical impact. A very similar argument, but on this occasion, the board said, yeah, that might be true. And on balance, we will refuse to get the Ministry, but Health New Zealand make deductions on an interim basis, and instead we'll have a substantive hearing to determine who's right and who's wrong. If it subsequently turns out that the Ministry wasn't entitled, first day wasn't entitled to make deductions, then at a later date, have recovered money. So very similar arguments, cases heard 2 weeks apart, both heard in the Employment Board, and exactly the opposite outcome. Typical of new law, typical of the unpredictability of the judicial system. So interesting and guaranteed that there will be further reaction about strikes happen. As far as next year is concerned, there are some changes that are worth bearing in mind. The removal of the 30-day rule is on the table. For those of you who know what that means, will know what that means. For those of you who don't have to know what that means, then don't bother about it. One of the things that it does mean is that it should be much easier to have 90-day trial periods in individual employment agreements. When the government reinstated 90-day trial periods, they forgot to do the 30-day rule part of it at the same time. And so having the 30-day rule come in should make it far easier for far more people to have 90-day trial periods. There is also the proposed removal of the active choice forms. Some of you will have been involved in setting up payroll systems and processes that are designed to flood into enormous amounts of information that they never understand. They're intended to be repealed. And also the obligation to pass on union information to new employees, and the obligation to pass on to unions the information about the names and addresses and contact details. It's also proposed to be repealed. Again, it's just a way fast to employ people, and also slightly harder for the union to conduct their recruitment campaigns, but still will have rights to conduct campaigns, but it won't be quite as easy as it was. So that's collective bargaining in a nutshell. Any questions? Brilliant. That means I can hand over to Aaron's comments. I'll be around after we want to discuss it.
I'm going to talk to you about, I'm going to talk to you about restructures and redundancy. Not potentially the most exciting topic, but one that probably you need to know. And probably one that's important right now. the key considerations, you're all fantastic KTC clients, and so you know about the key consideration for a restructure because you've probably all run them all, and you've all run them incredibly well, no doubt. But 5 key factors, things to consider in the restructure. The first is a genuine business reason. Obviously, not related to the individuals themselves, characteristics, point of view, but for a business reason that relates to finances or more efficiency, or reach a new structure, or a new way of doing things, or potentially just being closed down by Australia saying, let's move it into Australia, let's move it. Whatever that is, it needs to be a genuine business reason related to that and not involved. Relevant information, well, people ask, well, what is the relevant information? It's the information the structure relies on. So the proposal refer to information, assumptions, and that's the information or assumptions. The other interesting proposal. So it's important that the proposal be carefully drafted so that the right information is provided and you don't get drawn down to providing information you don't want to provide. Often it's financial information. Genuine consultation, no predetermination, or at least no predetermination anyone can find out about. And that leads you back to being careful in your communications. Beware the privacy of your request. And good faith, of course, everyone will be acting in good faith, responsive communication. And that often requires extension of that. A bit extra time here in the restructure process. And the last one is to consider redeployment, which we'll talk about more in a minute. But that's obviously, as Peter mentioned, use this seminar, something the employment population for. Have you thought about redeployment? Have you considered redeployment? Are you redeploying this to evolve that could do? And not just getting rid of the basis that they're not needed structure. So 5, and I promise it's only 5 practical tips that I thought might be useful to think about and just to keep in mind when you're planning a restructure or implementing a restructure. The first sounds obvious, to comply with employment agreements and policies, but Tower TV and Z didn't. And they were into trouble. A good employer will, of course, comply with its own policies. That's own employment agreements. And in some cases, there will be weird obligations in those agreements that you would never in a million years agree to now, but your predecessor in the 1980s or the 1990s or the 2000s thought, oh, we'll put that in, that's fine. You don't have to worry about that. They've long gone, but unfortunately you're stuck with whatever it said about redundancies in that collective agreement. So it's really important to have a look at all those things before you start. In the TVNZ case, there was a kind of pre-consultation process required by the collective agreement. So instead of just launching the proposal, it was a step we had to do first, which was talk to the union about basically how you could avoid a restructuring proposal. And TVNZ skipped that step. And the result was the employment court said, no, cancel everything, go back, do that step. Now, in reality, it made no difference whatsoever. And fair go, it was still cancelled. It was that's how effective fair go was. They couldn't get a fair go for themselves because TVNZ essence broke the rules. But it's just a delay, cost, bad publicity, but it didn't change the final outcome. Watch out for mixed motives. The courts, increasingly the restructures we're seeing are justified in the sense of they're about saving money. They're about working more efficiently, or they're about closing down this part of the business and moving it to Australia. So that's not the part that's being challenged in court. What's being challenged is the applicability of that overall process to one person. And one person says, that's fine to do this restructure. It's fine. But I'm not the person who made redundant. You can't make me redundant. One of the reasons you can't make me redundant is because it's not about, it's all unfair. It's about my performance. It's about an argument I had in Christmas party. It's about whatever it is. It's a mixed motive. So overall, the restructure might be fine, but when it applies to an individual, that individual say the employee has a mixed motive, and that makes the restructure unlawful as applied to me. So watch out for that. 3, 4, and 5 provide access to relevant information, including confidential information. So, as I said, the relevant information is the information in file, and therefore you need to be careful about what the purpose of the restructure is, and the information relates to the purpose. Financial information is one of the things that people, clients, don't like to provide on some occasions. And so, therefore, if you haven't got a financial motive for the restructure, in other words, about efficiency, reorganizing, removing middle management, it's not about saving money, it's about a more efficient organization. You can generally get away with not providing financial information. One of the things that the Act says is that you have to provide the relevant information unless doing so would cause unreasonable prejudice to the employer's commercial position. So basically that's confidential information, genuinely confidential information, could be genuinely confidential information about clients, financial information, but the employer is going to have to consider, is there a way of giving the employees that information? So yes, this would be terrible if it got out, but can we, for instance, create an information room where the employees come in and see it on a computer screen, but can take notes, but can't take it away? Is that a way of giving them information? Can you make them all sign non-disclosure agreements? Can you just tell the union delegates and not the union members? You've got to think about all the ways that you could provincially provide that information before it's justified in not providing it. And I would suggest there's going to be a very narrow range of exceptions where confidential information that is relevant is not disclosed in the market. But there might be some, and there has been a case recently where financial information, proprietary information was not disclosed. I said, that's fine. Consider a consultant selection criteria. Again, this is about the claim that the restructure is fine. It's just not me. It's ICRA who's made redundant, not me. I'm fine. Ringing the bell. It's ICRA, not me. I apply the selection criteria wrong. So that's one of the things to watch out for. It has to be in consultation. And then when it's applied in a transparent fashion as well, employees get to see how criteria have been applied to them. And the last part is consider redeployment to related companies. One of the things that has been kind of bubbling up is, okay, you've got a New Zealand company, you've got an Australian company, Singaporean company, all related. In fact, you might have a worldwide company, those here, where there are vacancies overseas, but not in New Zealand company. You see the same worldwide company but based in Singapore, Australia. And the court recently, in a case called Stellar Elements, said in that case there was a multi-country company, multinational company, various different places around the world, and particularly there were vacancies in Australia. But again, that company was called Stellar Elements Australia. Stellar Elements New Zealand had no vacancies, nothing for the employee to go to. But Stellar Elements Australia had some vacancies. And the court said it would have been fair and reasonable for the New Zealand employer to at least try to get an opportunity for that person to potentially move to Australia and work in a different country and different company to go related. So that's kind of where the court's heading on that issue. It's not just about redeployment within the company, but within potentially sister companies. That's all I have. Got any questions about any of that? Isn't that? Renata, I think that's Simon.
Kia ora, everyone. I'm going to spend the next 10 minutes briefly discussing some of the health issues that you might face in the workplace. I'm going to start with a very brief reminder from the statutory framework that applies that you'll all be familiar with. So from an ER perspective, obviously the key provisions in the Relations Act are the duty of good faith in section 4 of the Act and section 103A of the Act. As you know, the duty of good faith provides that the parties to an employment relationship must be active and productive in maintaining, well, actually constructive in maintaining a productive employment relationship. And that requires them to be communicative and responsive. You'll also know that under section 103A, the test as to whether an employer's actions were justifiable are whether they were fair and reasonable in circumstances at the time the dismissal or action occurred. From a health and safety perspective, under the Health and Safety Work Act 2015, and there are various obligations for different duty holders. Again, I think you'll be familiar with these, but the primary duty of care is owed by a PCBU, some person conducting business or undertaking. And this duty, as you know, requires the PCBU to ensure so far as is reasonably practicable, the health and safety of workers while they're at work. Some of you, some of you have maybe directors who have involvement, and you'll also be aware that officers have a due diligence obligation. And that means that they must ensure that they understand business, they keep up to date with health and safety matters, and that they ensure that there are appropriate processes and resources in place to manage risks. Workers, which includes employees, have a responsibility to take reasonable care for their own health and safety, but they also have an obligation to ensure that their acts or omissions don't adversely affect the health and safety of other people. The consequences of breaching the Health and Safety at Work Act can be significant. So individuals can face up to 5 years imprisonment or fines of up to $600,000, and companies can be fined up to $3 million. Mental health is just as important as physical safety in the workplace, and it's a core part of what health and safety actually means in practice. And I've set out on slides some fairly alarming statistics. So according to the latest New Zealand Health Report, 13% of adults report a high or a very high state of psychological distress. And that's almost double the rate just a few years ago. And at any given time, approximately 1 million New Zealanders are experiencing mental distress or illness. And what that means is that most, if not all, workplaces in the country are affected in some way. And again, you'll be aware that employers have a general duty to take reasonable steps to protect employees against psychological harm and to provide reasonable support to employees who are affected by mental health or disabilities. And the management of psychosocial risks has become an increasing focus area in relations with authority and the employment court. And we're also seeing in practice that employee representative and advocates are increasingly referring to the work-safe guidance on managing psychosocial risks. Some of you may be familiar with it. It's a very comprehensive document. It's about 85 pages. And in some cases, it's becoming weaponized where employees have gone on sick leave, where employers have tried to impose performance improvement plans, and then employee representatives are arguing before you can kind of embark on a PIP, you have to follow the steps that are set out in the guidance. But generally, psychosocial risks is anything in the work environment can harm a person's mental health, their well-being, or how they actually feel at work. And set out on the slide some kind of common examples of psychosocial risks, so excessive workload, or physical work environment, and bullying and harassment. And the courts are recognising the serious harm that bullying can cause employees, which has been reflected in a number of fairly significant awards. So case in point is Parker and Magna Carta. So this is Employment Relations Authority decision from last year. In this case, Mr. Parker suffered prolonged verbal abuse, threats, and humiliation from a company director. And that resulted in him in suffering from anxiety, depression, and PTSD-like symptoms. The ERA found in this case the employer had failed to provide a safe workplace. He successfully brought a claim for constructive dismissal and was awarded £105,000 in compensation. And I think what this means is that there's an increasing expectation that employers will actively identify, assess and manage these risks, and that they won't wait for harm to occur. And so HR teams, this means ensuring that you've got clear harassment policies, that they're accessible, that they are implemented in practice. There must also be kind of safe reporting channels and prompt investigation processes, and a kind of demonstrated commitment from leadership to set the tone. Another key recent case, very high profile, which we're familiar with, is the Susie Wiles case. As you'll know, she is a microbiologist at the University of Auckland, gained prominence during the pandemic, during which she faced sustained threats and harassment from the public due to her COVID-19 commentary. She raised repeated concerns with the university about her safety and well-being, and she later claimed that the university had failed to take reasonable steps to protect her. The case went to the ERA, and then on a challenge to the employment court, the employment court confirmed that the employer's duty to manage psychosocial risks extends beyond the physical workplace and ordinary working hours. So it found that employers must consider risks arising from work-related activities outside of the office. And so that includes online interactions. You must address psychosocial hazards such as harassment or cyberbullying, even where the harmful conduct originates from third parties. So the key point the report made in this case is that psychosocial risks don't stop at the office door at 5 p.m. And you have to think more broadly about how workers may be affected. And so you can't rely on passive support measures like EMP. And when an employee raises serious mental health concerns, more formal engagement has to take place, and workplace adjustments may be required. Another interesting point is in this, Susie Wiles is obviously the cost involved, which is a question whether it's worthwhile. So reporting her costs were £550,000 compared to £1.5 million in Florida. So I think in context, Mexican systems is been going very soon. To work. The position with respect to medical capacity largely remains the same. The test is the same. Relies on the historic case of the archaic language that there comes a testing time and work of then by fault. So the law does recognise that you can rely on some employees being on long-term sick and providing you follow a fair process. In terms of returns to work, where an employee's been absent for an extended period, you have a duty to assist or facilitate that return to work, and that obviously involves proactive engagement with the employee and consulting with them in relation to measures that you can take to safeguard their health and safety and health and safety of their colleagues. to prevent firmness within injury or aggravation. And then finally, in terms of legislative reforms, so again, aware that there are health and safety reforms in the offing in plans and talk about them later. So once again, one of you learned afterwards of these questions. Good evening. I'm Anthony Cousins. I'm a solicitor here at KTC. As a quick case law update, we just wanted to bring in touch on the recent Supreme Court case, obviously commonly referred to as Uber, before discussing briefly the gateway test. Obviously, like most of you will hear Uber case, it's been topical over the last years. And obviously last week, we received the latest installment in which the Supreme Court upheld the decisions of the lower courts that the four drivers and conditions were included and they were held into the end. Obviously, to determine this, the court was required to apply the tests under the Act, which include determining the real nature of the relationship. Obviously, when the court applied these principles, they did find that there was strong control exercised by Uber. This is through monitoring the performance standards and applying like a disciplinary process through the complaint system. There was a tiered loyalty scheme through Uber Pro, which was used to control drivers' information. And under this, the top performers could receive information such as location and duration of the trip. And they could also get access to airport fares, which was provided for money. Uber also operated under a three-strike rule, whereby drivers would be logged off the app if they particular rides in the road. Another example of the control. Although drivers were not integrated in the traditional sense that we have seen in the past, such as uniforms, they were integrated. They were found to be the base and fundamental to Uber's business. Furthermore, the economic reality of how this operated showed that they were not the business of their own account. They had no control over how they were charging price, and they could not build goodwill. Any goodwill we paid Uber as a platform. Courts also made comments around the actual contracts, which I think is going forward as employers and businesses can take more priority. It was described as window dressing, and that the terms were designed to cover what the real nature of the relationship was. But obviously the court is called to look beyond that. And the judgment does underscore that the substance of the relationship does prevail over the contract. Uber did try to make a claim that it was a platform where it facilitates a relationship between the driver and the rider, and that it was not involved in this relationship and it had no relationship with the drivers in terms of contract or however, the court found that a passenger could not reasonably expected to think they were contracting with the driver and they helped to begin that relationship is Uber. Obviously, the court did find that they are a transportation service and not a legitimate middleman. They claimed, obviously, it questions the industry practice, while can be considered. The fact that the industry considers that its workers are contracted is not safe. And it sends a clear message that contractual labels are not predictive of the reality of the relationship. And obviously, in this case, that's employment. It obviously suggests that drivers and other workers in similar digital platforms may potentially be classified in the future as employees if they feel similar levels of control. Of course, each case will need to be considered on the facts. Inherently, there are and there will be cases where employment status is questioned, and now the case will be part of the way forward. It reconfirmed all of the cases status. Obviously, it does follow a trend that the last couple of years. We've seen other cases in the employment court, such as the Bread of Life Christian Church in Chen. Obviously, slightly different being about pasta, but he was about to be a discussed. But obviously there are a few things on the horizon that may change this. So yeah, thanks, yes.
Okay, good evening, everyone. My name is Jade Suter. I'm a senior associate here at ATC. Today, I wanted to focus on what employers need to know around engaging workers, as independent contractors, and how to assess the true nature of that relationship. What we heard from Anthony today, and whilst I don't think anyone in this room would be in a similar organisation with Uber, what that case really came down to is how important assessing the true nature of that relationship is. From what we see every day, employers typically engage independent contractors on specialist tasks, on projects, short-term, or on non-related business activities. However, what we do see is that these relationships can change over time. They can evolve, they can create unexpected risk, to the extent that maybe employment status. Some of the examples that I've become aware of over the past few years seem quite innocuous, I think, at first glance. For example, an IT contractor might have been employed for a period of time, maybe been on successive fixed-term contracts, and then they decide that they want to set up their own business and they want to invoice to essentially provide the same service they were previously providing as an employee. Another example, a graphic designer worked for a company for a long time, was made redundant. A few months later, they've come back providing a short-term project service. But then over the course of time, that person who was an employee, who was legitimately engaged, perhaps as an independent contractor, then starts doing ongoing day-to-day work such that the relationship may be like a relationship. Now, on the face of it, this independent contractor may have been an independent contractor for providing a set graphic design service, but as that relationship evolved, it changed. And some of the things that employers need to think about is, how do you manage that change? What does it look like? And kind of what does it feel like? And how that risk profile might change if both of these examples, they have set up their own companies. Are they providing their services to other organisations? Are they able to arrange other key staff to perform services or subcontract work? So when assessing the true nature of a relationship with an independent contractor, businesses need to assess the control. How much control does the employer have over the worker's activities? Can they manage their own work? Can they deliver a task or a project on an agreed date and in their own and can they work on what they want? Another key factor is integration. Is the work integrated into the employer's business, or are they operating independently? The economic reality. Do they have other clients? Are they able to negotiate their own rates and terms? Do they have their own insurance and equipment? Do they pay their own taxes? And again, can they subcontract to other language to provide services? And the fundamental test, are they really working on their own? Uber case confirms that the control dependency of economic reality. So to provide clarity moving forward, Workplace Relations and Safety Minister, the Honourable Brooke Van Bell, has introduced amendments to the Employment Relations Act that propose a gateway test, which you can see it up here on the screen at the moment. The proposed gateway test intends to conclusively classify whether a worker is a contractor or not if they meet this gateway test. Bill is currently at select committee stage, and apparently I'm going to have a report published on Christmas Eve, although it seems to me unlikely. So the proposed gateway test would require that there is a written agreement specifying with the worker as an independent contractor that there are no restrictions on working for other businesses, including competitors. Flexibility in how the work is done with the ability to subcontract and having no penalty for turning down. So with this new legislation being proposed and a little bit of uncertainty, we expect that there may be some changes to the legislation as proposed. Some top tips for employers who want to get ready and to review their contracts and business practices. We recommend you have a look at your contractor agreements and check at the moment, are they satisfying these tests and all elements of the gateway tests? And if not, how can you strengthen your contractor status with tailored agreements? Do you have a process or documents to onboard and manage these independent contractors in the business and periodically assess the treatment so that you don't get this kind of scope creep, which happens so naturally in organizations? And make sure you reevaluate worker incentives and controls.
Just add something as well. I'm from BDL where one thing I want to add is tax obligations for employee versus independent contractor. Very important and can trip employers up. Employment taxes is going to be an area of focus for IIT. So with the Uber case, it'd be interesting to see what IIT's position is. So yeah, independent contractor versus employee status. So my expectation.
So that could be another thing that should be assessing. And then having a look at, is there risk in your business? Could you have independent contractors right now, gateway tests, that could bring an employment status claim under the existing legal tests? If they can, maybe it's an opportunity to reevaluate to build some contractual flexibility to put in express rights around subcontracting, the right to refuse work and to engage with competitors. And obviously looking at the overall day-to-day business practices and whether they're consistent with the contracts and that's what practice are set out to do. Again, it comes down to the true nature of the relationship. Understanding this framework is essential for employers and workers alike. We know that new work models continue to emerge. We've seen that in Uber's decision. Business needs change, and we're also looking at potential legislative change. Despite this, concerns remain that the new legislation as proposed may not be the silver bullet to address all of these uncertainties. So it'll be interesting to see how that will develop. And of course, it's challenged. I'll be around after we questions.
Good, Tato. All right, I am now going to run us through very quickly, hopefully, changes that are on the horizon next year, or at least some of the key ones. The very first being actually the one that the team has just discussed. And this is going to come as part of what is an omnibus bill, really, the Employment Relations Amendment Bill. As Jaya mentioned, we're expecting Select Committee to report back Christmas Eve. So second reading sometime in the new year, but Parliament gets back late January, so goodness knows exactly when that'll be, but certainly on the cards. Now, this contains some quite radical changes, and then others that we probably would have expected the government to make some time ago. And it is part of the government's going for growth agenda. It's a bit of a tongue twister there. But the intention really is that the government is trying to make our business settings more competitive. There's an aim to enhance labour market flexibility, reduce those compliance costs, and also retilt the PG systems terminology they're using to best balance those employer and employee interests and discourage poor behaviour from employees. So that is the aim. The first piece on there is the gateway test, which Jaya has run us through. So the changes to Section 6 that we are expecting are going to come as part of this omnibus bill, not a separate piece of legislation as one might have expected, given the long discussion we've had about that gateway test. The next big change is going to be this $180,000 threshold. And I think if this goes through, which we can expect, it will change quite significantly how we deal with many matters, because we're framing 180 as high income earners, but I know most of you in the room will probably agree with me that that encompasses a lot of people. You know, a lot of people are above that threshold. Australia have a very similar threshold, so we're not out of line internationally with this one, but it is going to change things. The deal is this: there's going to be a threshold, which will initially be set at that 180,000 mark per annum. It's going to be updated annually to reflect average changes. And if you are above this level of earning, you are going to be excluded from raising a personal grievance for unjustified dismissal and any unjustified disadvantage claim that relates only to that dismissal. So you're cut out of that PG framework, and employers will not need to comply with their duties of good faith in terms of how they go about dismissing these people above that threshold, and won't need to give that reason for dismissal under Section 120 Act. Now, there is an ability for employers and employees to contract back in, but I don't anticipate that we'll see much of that at all. It will be, though, a 12-month transitional period comes in, though, so those on existing employment agreements will still have the right. So we may see a little bit of a rush for those PGs to everyone. I think a little bit of a shift, though, in terms of how we approach matters. The next point, and this one is, in my opinion, potentially subject to change. I think we're going to see a lot of comment in the Select Committee report about this, but the next one there relates to remedies and how, whether they're available for employees who have contributed in some way to that grievance. Now, what the bill is currently proposing is to remove eligibility for any remedies for employees whose behaviour amounts to serious misconduct. Now, of course, the question is, what is serious misconduct? That's not, you know, I think we're going to have some issues around that, and maybe some refinement next version of the bill potentially there. There's also been a provision that the court or authority must not provide for certain remedies if it determines that an action or any action of the employee contributed to the situation that gave rise to the check. Now, in terms of those remedies, that's reinstatement and your section 1231C remedies, so H&H, and also loss of income, but the loss of wages still stays in there. But that's going to be an interesting one to see if that stays intact. The bill also clarifies that remedy reduction of up to 100% is available for the court, so they can strike those remedies right down to zero. And then, interestingly, there's going to also be a change to the test of justification, section 103, capital A test. First of all, in relation to procedural errors, so you know at the moment that where there's a minor error that results in unfairness to the, sorry, that doesn't result in unfairness to the employee, that can be that can be looked over. But here what we're going to see is whether there's if there's any errors at all in the employer's process. So long as they don't result in unfair treatment, they're going to be allowed. So a little bit of a tweak there to that test of justification. It's something that I think wasn't usually part of the conversation before this came in. So we'll see how that spits out at Select Committee stage. And then another probably quite helpful one for most of you in the room is that the court or the authority must consider whether the employer's behaviour was obstructed, whether the employee's behaviour obstructed the employer's ability to meet their obligations to be a fair and reasonable employer. So those obligations, sufficiently investigating, putting matters to the employee, giving them time to consider and an opportunity to respond before decisions made. We do, and I know all of you in the room will have instances where employees are obstructing your ability to conduct that fair process If that's the case, following this legislative change, the court is going to need to take that into account. So probably quite useful for many of us in the room. And lastly, there that 30-day rule that Andrew mentioned, that will be out the door, we expect. So, Omnibus Bill there, a number of changes all wrapped up into one piece of legislation. Another change that is on the cards for us, this one here is up to its reading, is the employment relations termination of employment by agreement. Now, this is going to allow for protected negotiations between an employer and an employee to terminate employment. It's going to allow for an employer to seek mutual agreement with the employee, sign a settlement agreement which employment terminates, and which the employer does make payments to the employee in exchange. And this is, of course, something that we will do really at the moment. However, currently, we need an employment relationship problem, and we're relying on privilege to have those discussions. Well, if this change does come into effect, it is going to allow that process to be a lot smoother. You're just going to need to have an offer with termination and a specified start. So both of those boxes will need to be ticked. There's going to be some requirements for that offer as well, allowing the employee to seek independent advice. But so long as those requirements are met, the offer can't form a personal agreement, so neither can those pre-contractual negotiations. So that will be, I think, a useful one for us should it come to pass. The next one here, and I could probably speak to you all for about 2 hours on this. The Employment Leave Act, which, for about the past 5 years, we've had a slide up here, the Holidays Act. I'm glad to report that I don't have that anymore. It is the Employment Leave Act that we are expecting to see anytime soon. The Minister has indicated she wants it done this term, but really complete overhaul of our Holidays Act framework. You'll all know that there was an exposure draft earlier this year, maybe the end of last, that got consulted on, turfed out, wasn't good enough. We matched the drawing solution. The devil is very much in the detail here. I only know as much as you all do in terms of what it's going to look like, a summary of what the aims are, simplification, hours-based accrual, and the like. But we don't know exactly how it's going to pan out until we see that legislation. Key things though, and I know a lot of you will be very happy to see that hours-based. So we're going to be looking at the hours-based system for annual leave and also for sick leave as well, and that sick leave will be prorated. So you've got that awkward situation at the moment, 10 days no matter what, that is going to change. Bereavement and family violence, all available from day one and still days based for those ones. There's going to be a new otherwise working day test for those public holidays, which should make things a little bit simpler. I know I've spoken to a couple of you in the room about that, and it's often a tricky one. The big one, though, is that pay rates for holidays is going to be simplified based on a base wage. So hopefully the same for everything. Very straightforward. Fixed allowances included to be paid during leave, and the dip that happens after volunteer leave or after someone takes parental leave is not going to be paid. So that standard wage is going to apply, say from day one. So they're not disadvantaged. Casuals and people who work additional hours are going to now have something called a leave compensation payment, a 12.5% payment that is going to be made instead of the accruing those 16 hours. And then there's a little bit of an interesting thing around pay statements. It's going to be, obviously there's going to be a lot of change that is required in terms of systems. One of those changes also is going to be documented and provided to probably quite detailed as far as we can tell, and sufficient to allow them to check that you as an employer. So lots of change there. I am expecting a bill any day, but and then very quickly, just something that Simon flagged. Again, we haven't seen this legislation, but there are going to be some changes to the Health and Safety Work Act. I think one of the big ones is that for small and low risk businesses, they are going to see change in their obligations, requiring only a focus on management risk. So the idea from the minister is that she wants to cut red tape here. So a bit of a change, particularly for those smaller businesses. Also some changes around notifications, with those will be key to look out for when we get that legislation in terms of what you need to say know about for that. What we have done, so I know that was a whirlwind and I haven't covered everything that is on the horizon. We have, the team has worked really to produce a wee bit of a handy guide for you all in terms of what we've seen, stuff that Peter mentioned and what is on the horizon. It's Anthony Campos is standing there holding it out. One side has the key amendments this year that we've seen, and the other has what's on the horizon. So feel free to take a couple of those if you want to get to me, or just a handy guide as at today for your pin board or whatever it might be. And I will leave you now with Peter to wrap us up.
Thank you very much, Hannah. I just want to point out that David France, Anthony Camphorst, and Ikra Khan are also here, part of the team. So I know many of you deal with them. Don't hesitate to bail them up, apart from the speakers that we heard. I think colloquially, when I look at the 2 pages, what's the sum up is, wow, there's an awful lot happening. So we are all involved in employment law. There's good news and bad news. The bad news is there's a lot happening and a lot of it's uncertain. The good news is I think we'll all keep our jobs because there is just so much on the horizon, and it's piecemeal and it's come in dribs and drabs through the year, and there's a lot on the horizon. So I think you'll find the 2-page flyer that we've left you to take home quite useful. I didn't see anyone fall asleep, but you're all awake. We've deliberately kept it for an hour. So as I said at the start, don't hesitate to give us your feedback and thoughts too, and don't hesitate to bail up the team and enjoy some hospitality on us. Thank you very much for attending.